Well, good afternoon, and welcome to today's webinar presented by Beresford Booth. My name is Per Oscarsson. I'm a member of the firm's estate planning and probate group, and the topic today is how do my debts get paid in a probate? And this will apply whether there is a will or if there's not a will, otherwise known as intestacy. There are some differences, mainly because with the will, it is possible to change some of the rules that we'll be talking about. But in intestacy, there is no way to change some of those that would apply by statute. So the question of how do my debts get paid is actually quite a simple question. And unfortunately, the answers range from simple to more complex. Today, I'll just be giving a general overview of the process. We won't get down into a lot of the detail for most of it. Really, it comes down to two parts. One is determining the debts that are to be paid. And the second part is actually paying those debts. This is one of the key responsibilities of the personal representative in any probate estate, because if valid claims are not addressed in the probate by the personal representative, the creditors for those claims could somehow follow the assets into the hands of beneficiaries, or it could result in claims against beneficiaries who receive assets from the probate estate when claims have not been fully paid. And beneficiaries typically do not want to receive any kind of property when there's a claim attached to it. There are some claims that won't really be affected in the same way by some of the things I talk about today, such as a loan secured by a real estate mortgage or deed of trust. Because the security interest provided by that mortgage or deed of trust will continue whether a creditor may file a creditor's claim or not. So the first part, determining the debts to be paid. The personal representative typically will review the deceased person's records and correspondence to see if they can find any evidence of any kind of a claim, and then determine the validity or invalidity of that claim. These could include things like credit card statements, utility bills, bank statements, loan statements, medical hospital bills, and letters or other types of communication. One way that a personal representative can figure out what all those claims are or may be is to publish notice, and that can be part of the normal probate process. But it's a voluntary process for the personal representative. They can choose whether or not to do that. It is a process that's provided by statute. One of the advantages of publishing the notice is that it shortens the time available for a creditor to provide a claim to the estate. So if there's, for example, if there's no publication, the creditor who has the claim may have until the applicable statute of limitations runs. And that could be up to 10 years, depending upon the nature of the claim. Typically, we would not want to see a probate stay open that long, although there are cases where they have stayed open that long. Publishing the notice reduces that time for a creditor to file a claim to 24 months from the first date of publication. Typically, the publication is 3 consecutive weeks, once a week for 3 consecutive weeks. So publishing drops that potential 10-year statute of limitations period down to 24 months. That can be further reduced by giving the creditors actual notice. And that involves either personally serving or mailing a copy of the notice to creditors that gets published in the newspaper to the creditor. This then shortens the time for them to file a claim in the probate to the later of 4 months after the date of first publication, or 30 days after the date of service of the notice to creditors on that creditor, or mailing of the notice to that creditor. A second advantage is that this process can bar claims of creditors. They may have been valid claims, but if the creditor has not filed the claim, they may be barred and will forever barred from pursuing the claim. Creditors are also barred from filing a claim if an applicable statute of limitations has already barred the claim. There could have been a claim that had been outstanding for 5 years, as an example, and the applicable statute of limitations might have been 3 years at the time that the deceased person died. In that case, there's no benefit to filing the claim because it's already barred by an applicable statute of limitations. A third advantage of doing the publication of notice to creditors, it allows the personal representative to discover claims for which there may be no records in the deceased person's belongings. An example I like to use is an automobile accident where the deceased person is or may be at fault. They may be embarrassed to tell anyone, and no one in the family or friends even know that anything has happened. And it's entirely possible that there are no records in among the deceased's belongings that indicate that there was ever any kind of an accident, whether they were at fault or potentially at fault or not at fault at all. But publishing the notice to creditors gives the opportunity for the personal representative to find out about such claims. And if they're not filed in time, they're barred. So the personal representative then reviews the creditor's claims that are filed. And very often there are very few creditors' claims filed, but the personal representative is still looking at loan statements or credit card statements to see if a claim might otherwise be valid, and they may otherwise still pay that claim. The personal representative then accepts or rejects the claim, and if they reject the claim, then the creditor has the ability to bring a lawsuit in the context of the probate to allow the court that's administering the probate to determine whether or not this is a valid claim, and if so, the amount of the claim. Now, whether to publish in any particular probate could depend on a number of circumstances. So, for example, if the personal representative who's appointed in the probate had served as the attorney-in-fact under a power of attorney for the deceased person, and that person was incapacitated for the last several years of their life, and this personal representative, in their capacity as the attorney-in-fact, was actively involved in the daily activities of that incapacitated person, that may have included paying bills. And they would be the personal representative, as attorney-in-fact, would most likely be very familiar with whatever debts the incapacitated person had. In that case, they might determine it's not necessary to publish notice to creditors because they already feel comfortable that they know of all of them. Kind of a very different example is the personal representative who might be a family member or a friend, but they have not been actively involved in pre-death activities of the deceased. And so they may have little or no idea of the deceased's debts. And in that case, publication probably makes sense because the personal representative wants to make sure that they get the debts taken care of. Now we get to the actually paying the debt. And generally, the rule is that the payment comes from estate assets. Now, this could be probate assets. That's property that's covered by the will, or if there is no will, it's not covered by some other form of ownership, which would be non-probate assets. And the non-probate assets are things like a transfer on death bank account or investment account, a payable on death bank account or investment account, or some asset, often real estate, held as joint tenant with right of survivorship with one or more other people. In those cases, the law already provides how that property gets distributed. Where you have a payable on death or transfer on death account, there's typically a beneficiary named on that account. When the owner of the account dies, very often it's a pretty simple process for the beneficiary to get control of that asset, that account, by providing possibly a death certificate and proof that they are the beneficiary named in the documents. If it's a joint tenancy with right of survivorship asset, the law says that when one joint owner dies, the remaining joint owners receive that interest. And if there's only one joint owner or joint tenant remaining alive, that person now has, or entity, could be an entity, now has the entire ownership of that asset. So I said this could be very simple or it could be very complex. So here's an example of the simple situation for paying the debts. Assume there's a will, and the will is silent on the issue of how the debts get paid. The estate is solvent, that is, the assets of the estate exceed the liabilities. Typically, in that case, the claims would be paid from the residue or the residuary of the estate, and that's everything that's left after specific bequests have been made. A specific bequest, for example, like I give my car to my daughter. Well, if that's the only specific bequest, everything else that is a probate asset falls into the residue of the estate, and the expenses, the creditor claims, etc., would get paid from the residue. Now, another possibility is that the will specifically provides which portion or portions of the estate are to pay certain claims. That's one of these things that allows for the maker of the will, the deceased, to have some control over how those creditor claims get paid. Another one that might be considered even more complex, let's assume that there are a large amount of claims. But let's also assume that the residue of the estate is not large enough to pay all of those claims, all of the allowed claims. There may be a number of specific bequests that could help reduce the size of the residue. Or there could be a lot of non-probate assets that are involved in administering the total estate of the deceased. Those non-probate assets are not subject to the rules of probate, typically, although under certain circumstances they may be. The Washington probate statutes provide for how property is to be used to pay claims in those cases. And it may involve some assets in various classes may have to be sold to raise the funds to pay the claims. But again, the will can also provide how property is to be used to pay claims in those cases. And that whatever language is in the will would override the statutory provisions. So again, it all ends up with the estate is the one that is paying the claims. Now, if there's an insolvent estate, so the liabilities exceed the assets, then creditors may not all get paid. And some classes of creditors, because there are different priorities of classes, and the rule is that all claims in one particular class will have to get paid before any payment gets to a lower or a junior class. That also means that there will be nothing available for distribution to the heirs or beneficiaries because it's all going to pay the claims against the estate. One of the issues that can arise is if there are distributions of property before valid claims have been paid in full, then the personal representative may see a claim being made by the creditor against them or their performance bond, if a bond has been required. But the beneficiaries who receive the property might also see or be faced with claims for contribution to pay that creditor claim in some proportion based on what the beneficiary received from the estate. And so it's always important, particularly with the high priority claims, that those claims be addressed and paid in full. Now, it may not be the amount that the creditor has claimed, because there may be there may be evidence that the claim is incorrect, maybe not fraudulent, but incorrect. And that can help reduce the amount of the claim that has to be paid. But eventually that claim would be paid, and with good luck, there are enough assets in the estate to pay that and still provide to the beneficiaries. And that's pretty much it in a nutshell. I hope this has been helpful to you, and I thank you for joining us.